Good afternoon, everybody. Good afternoon, everybody.
Good afternoon.
Good afternoon, everybody. Okay, thank you. I'm glad you're all awake. Welcome to the Latham Watkins Forum, the state of death penalty, 50 years after Furman. And really, we are 51 years after Furman because Furman was decided in 1972, but I can't do math. We have two phenomenal guests with us today to talk about the state of death penalty as it currently stands. And I'll begin by introducing them both. Seated to my immediate left is Alexis Hogue-Bourgeois. She's an assistant professor of law and co-director of the Center for Criminal Justice at Brooklyn Law School. She teaches in rights and criminal law and procedure, evidence, and abolition at Brooklyn Law, where she co-directs that center. Prior to joining law school, she served as the inaugural practitioner in residence at the Eric J. H. Holder Jr. Initiative for Civil and Political Rights at Columbia University, and is a lecturer at Columbia Law School. She spent more than a decade as a civil rights and criminal defense lawyer, primarily representing capitally convicted clients in federal post-conviction proceedings with the NAACP Legal Defense Fund, the Office for the Federal Public Defender in Nashville, Tennessee. She graduated from Yale University and this law school, where she was a Derrick Bell Public Interest Scholar. She served as a law clerk for the late Judge John T. Nixon of the United States District Court for the Middle District of Tennessee. She also serves on the boards of the Death Penalty Information Center, the Eighth Amendment Project, and the editorial board of the Amicus Journal, and co-chairs the Capital Punishment Committee of the New York City Bar Association. Seated to her left is Aran Ajoyan, who's a supervisory assistant federal defender in the Capital Habeas Unit of the Federal Community Defender Office for the Eastern District of Pennsylvania. He's also an adjunct professor of law at Drexel University Klein School of Law. He represents individuals who have been sentenced to death in post-conviction proceedings in multiple jurisdictions throughout the country. He also co-teaches a class on death penalty law. He previously worked as a fellowship attorney at the Office of the Georgia Capital Defender in Atlanta. He represented capitally charged clients at trial and on direct appeal. He received his law degree from Harvard Law School and an undergraduate degree from Northwestern University. So please join me in welcoming our phenomenal guests. So what I'm hoping to do today is kind of start by talking to you about your careers and career paths and how you got involved in this type of work, and then shift gears to talking about Furman and the current kind of state of affairs in the wake of Furman and Gregg, which was decided 4 years later. And then close by giving you all a chance to ask some questions. So why don't we start with the kind of preliminaries about your careers and career paths. And I'll start with you, Alexis. How did you actually get involved in capital work?
Yeah, thank you. It's also a pleasure to be back here, back in Greenburgh. If I had been sitting in this audience as a 1, 2, or even a 3L, and you had told me you will be a death penalty defense appellate lawyer in Tennessee for almost a decade, I would have said, no way. Those of you here, you know that there tends to be sort of a smaller group of very committed capital, sort of death penalty focused students that do summer internships, work with Bryan Stevenson and Equal Justice Initiative. I was not one of those students. I was in the criminal defense clinics. I summered at Bronx Defenders. I felt very strongly about indigent defense. I didn't really know as much about post-conviction representation. I had a seminar with Bryan, so it was sort of on my radar. And then I went to clerk in Nashville, Tennessee, at the Middle District in a federal district court. And I saw for the first time federal public defenders. They seemed to have far lower caseloads. There was really powerful and effective oral and written advocacy, and it was sort of a path and an institution I didn't know as much about while I was in law school. It also bought me some time, that clerkship year, to think about what it is that I wanted to do. And the clerk in the court, the deputy, told me to send my resume across the street to the federal defender. And I asked him to coffee. And he never responded, but his assistant got back to me and said, you have an interview. And I said, for what job? And she said, there's an opening in the Capital Habeas Unit. This is the same unit that Aran works in. And I had to do a little research about capital habeas. I hadn't taken Fed courts. I didn't know about sort of the relationship between federal courts and state convictions and what happens in the appeals process. But I sat there and I talked about my commitment to indigent defense, that I believed that people were worth more than the worst thing that they had ever done. My experience working with people that had mental health issues, and they said, "You're hired." So I somewhat, happenstance, like fell into the work. I had very deep relationships with my clients. I was doing dynamic, interesting work with experts, talking to jurors. I was on the road. I was visiting clients. I was reading a lot of documents. I was writing a lot of briefs. But it was a dynamic practice of law that I didn't quite know about. I didn't know I was prepared for it until I started. And it's work I continue to do even in academia. So when I left the federal defenders, I went to LDF, where Vincent has also worked, mostly working on capital cases. And I still represent a young man who's on federal death row in his appeals process.
Great. Thank you, Alexis. Aaron.
Yes, absolutely. Just want to echo the thanks for having me here and all of you coming. It's really a pleasure to be here with you all. So I started, in perhaps a similar vein. I was very committed to the idea of becoming a public defender from very early on in my law school career. I knew it was sort of among the things that I wanted to do, and very quickly into my 1L year, I settled on being a public defender as what I wanted my career to be. My first year crim professor was a former public defender and a very big influence on me and my career path. But I wasn't exactly sure necessarily that I wanted to do capital work. I had sort of long-standing views on the death penalty, and I felt strongly about them. But I was open to the idea of being sort of a quote-unquote regular public defender, doing trial work or appeals work. And so I spent my first summer at a more traditional public defender office. I spent my second summer doing capital work. And at that point, when I was applying for jobs, I was really, open to anything. I was pretty untethered geographically, and I, interviewed for and applied for the job in Atlanta. That was my first job out of law school. It felt like it was a brand new place to me. It was sort of a new, exciting adventure in that sense. But I felt good about the office and felt very strongly about moving forward in that way. And then, even when I've really only had 2 legal jobs, I've been at the federal defender in Philadelphia since 2008, after just 2 years in Atlanta. But I wasn't committed to continuing to do capital work necessarily. I was also applying to public defender jobs as well, to develop trial skills and things like that. But when the opportunity came in Philly, I kind of jumped on it. I similarly did not really know anything about habeas law at the time, and so kind of gave myself a crash course on it between applying for the job and going up for the interview. But obviously that's been all I've done ever since, really. And I similarly really enjoy the variety of it. There's really not many other areas of law that I can think about where you're getting to do in-court advocacy, both in terms of putting up witnesses at evidentiary hearings, doing oral arguments, also getting to do the investigative piece, but at the same time, really getting to do a lot of the research and writing that you don't necessarily have the time to do when you're a busy trial lawyer or something like that. And then of course, most importantly for me is the ability to really develop these much longer standing and in-depth relationships with my clients than you just by the nature of your caseload and how quickly your cases move than you would in a different area of public defender practice. So
Great. I'm wondering, I guess, if you can maybe talk to us, and I'll start with Aaron, if you could talk to us about kind of your most memorable case or client that comes to mind for you.
Sure. Well, that's, I was thinking about that question in advance of this panel, and I think it's a really tough question for me to answer because, I have so many clients that are memorable to me for so many different reasons. You definitely experience very high highs and low lows in this job. I have clients who are very memorable to me because they're no longer with us, because they have been executed. I have clients that are very memorable to me because they're no longer in prison, which is obviously a much better outcome from my perspective. And so, just this past year, 2022, I was very, fortunate and grateful that two of my clients were able to get out of prison, not just no longer be on under death sentence, but be fully out of prison. But during during the pandemic, just before and kind of throughout the early stages of the pandemic, I had three clients who I lost in about a 1.5 year period. So, all of those cases are profoundly memorable to me. In addition to, really all my other cases, I haven't had a huge number of clients, like 25, 30, 35, somewhere in that range over the course of my career. So, I remember them all pretty well. Yeah.
Yeah, Alexis, same question for you.
Yeah, I have a similar experience, extreme highs, extreme lows in the practice. The clients that I had in Tennessee, they're all still with us. Tennessee courts move quite slowly, the federal courts. And I'm actually still in touch with many of them, even though I left that office in 2017. And one client in particular, this was my first job out of the clerkship. And so I was relatively young. I think when many of my clients met me, they wondered if I was even old enough to have graduated law school. And so it was always sort of an initial having to show my clients that they could trust me. And this is going to be true for you in any sort of setting, particularly earlier in your career. But it's vital in a capital case. And for one client in particular, I was the 8th attorney that he had encountered through the appeals process. He sort of sized me up, kept me at arm's length distance. We realized in investigating his social history and intergenerational sort of family history, medical history, that he had really severed relationships with family members. And he had one brother in particular that he hadn't spoken to in about 35 years. And so during this sort of pre-investigation phase, in between the time we were assigned or appointed as counsel, and then we filed the initial petition for habeas corpus relief, we're investigating, right? On the road with investigators, my colleagues and I, usually in sets of 2, talking to family members, talking to former trial lawyers. But we ended up finding his brother, connecting with his brother, visiting with his brother several times. And right before we sort of filed our big document in court, we had all these attachments of affidavits, declarations from family members. And he'd wanted to read them, and he read the one from his brother. And he showed very little reaction in person. And then later on, he told me that he reached out to his brother and that they spoke. And being able to reconnect that bridge after a 35-year gap was really powerful. And it's a case, it's still pending. You have to redefine victory in these cases. But to me, that was a massive victory, being able to reconnect my client with his brother. I had another case where I actually wasn't assigned counsel. It was while I was at the Legal Defense Fund. And we had participated more often as amicus advocates in cases both at the state and federal court. And so this was a case before the Ohio Supreme Court. The client had been sentenced to death. It was on direct appeal. So someone in Ohio reached out to LDF and said, we think there's a really significant claim of racial discrimination, that one of the jurors indicated on a written questionnaire that she believed Black people were more inherently dangerous. And then she was actually selected and served on the jury that sentenced the client, convicted the client and sentenced the client to death. And so we came in as amicus, wrote a brief, split time and oral argument before the Ohio Supreme Court. And Ohio is a state that actually does sort of live streaming during the arguments. I wish our US Supreme Court did that. And the client, the appellate, was watching while incarcerated. And I had some time before I flew back to New York, where LDF's offices were, to visit him on the row in Ohio. It was about an hour and a half from the airport. And he said I was the first Black lawyer that he'd ever met, that he was so excited to have seen me. And it was like I was wearing a cape, which, you don't have to hear these things, but like a superhero cape. But it was just a really beautiful moment. And that much more so when the Ohio Supreme Court overturned the death sentence and the conviction.
Great. Now, before we kind of start talking about Furman in more detail, I wanted to ask both of you. You both mentioned kind of the incredible lows and challenges of this work. And I'm just curious if you can share with us how you sustain yourself in doing this work, how you protect your peace of mind. Alexis.
Yeah, talk therapy. I'm a big proponent And I started going while I was in law school in New York, and then in Tennessee I found a local therapist, but that was vital to my practice. I realized very quickly that I needed to be the best version of myself, to be the best advocate on behalf of my clients. It was also critical to me to have activities that had nothing to do with my work. I joined a running club sort of in my neighborhood. So I met people when I first moved. I grew up in California. I was obviously here for school. So I was just trying to get to know this new city. So running, signing up for local sort of road races, fostering dogs. I had a yard in Tennessee. It was much easier to do there than in New York City. But it's so critical to take care of yourself. And to be the best lawyer you can be, but also to be a good partner, a good friend, maintain your healthy relationships. It's easy to give your whole self to your job in any sort of part of the law, but that's not going to be a sustainable way to practice.
Yeah, no, I agree with that so much. I mean, and I'll put in a second plug for talk therapy, which, my first client who was executed at the very end of 2019, and that happened, like I said, 3 times in about the course of 18 months, unfortunately, and that it was also coincided with the pandemic and a lot of other things that had going on in life, I think just given the nature of the type of work that we're dealing with, given the types of cases we're working with, given the types of trauma and mental health issues that you're dealing with in your cases, it was, of course, never lost on me that this was difficult work, that this was challenging and draining, but I don't know that it ever hit me in the way that it did until I got into this place where I had cases that were ending in the worst possible way, that the full weight of everything really kind of was sitting with me. And so I really started to think a lot more actively at that point about wellness, about making sure I was taking care of myself. And everything, I just want to echo all of it that was just said, because if you're not being your best self, you can't focus as well as you want to. You can't. You're not going to have the level of energy that you need to ensure that your clients are getting the very best representation. And just at that point where you're starting to get the level of experience where you feel like you're starting to put it together a little bit, can be when things start to feel the hardest, and the burdens of everything that you've been dealing with so many years start to feel a little bit heavier. So I think particularly as you get a little further in your career, but really from the very beginning, it's critical to make time for that.
Thank you both for sharing that. I mean, I think it's pretty clear to me, you can't save other people from drowning if you're drowning too, right? And so it is really, really critically important. So I want to shift gears a little bit and talk about Furman. And I guess I'll start by giving kind of a brief thumbnail sketch of the case, and then kind of start to ask you some questions about it and about the current state of affairs. So this is a case that was decided in 1972 by the Supreme Court, which held in a 5-4 decision that the death penalty, as it then existed, was cruel and unusual punishment under the 8th Amendment to the United States Constitution, and therefore unconstitutional, which meant that in places where the death penalty existed at that time and was practiced, 40 states and the federal government ended immediately. It nullified all death sentences, all pending death penalty prosecutions, and the practice ended. And the story really began, I think, a decade before that. There was a dissent by Justice Goldberg, in this case, Rudolph versus Alabama. Mr. Rudolph had been convicted of the rape of a white woman. He was a black man and had been sentenced to death. And it was a dissent from Grant Certiorari. Justice Goldberg was joined by Justice Brennan and William O. Douglas, who also wrote joining him, and essentially raised this question about whether or not the death penalty was unconstitutional under the 8th Amendment, and at least asked the court to address the question itself. That got the attention of the NAACP Legal Defense Fund and the ACLU, and together they kind of launched this nationwide campaign to really throw sand in the gears of the machinery of death and to really stop the death penalty altogether. And so they mounted this kind of litigation strategy, challenging death penalty cases across the country, and in the hopes that those cases would eventually reach the Supreme Court. Furman was one of those cases that did reach the Supreme Court, and as you all know from what I just said, it was a successful challenge. And the interesting thing about Furman was it was one of these cases I think that was incredibly rare in the sense that you have 9 justices. All 9 justices wrote their own opinions in the case. So you'll have close to 300 pages of opinions. And the 5 majority opinions, basically 2 justices said the death penalty is unconstitutional under all circumstances, cruel and unusual under all circumstances whatsoever. 3 other justices said it was unconstitutional because of the procedures that were in place to allow death penalties to be imposed. And essentially at the time, there were no real procedures. The discretion was left completely up to juries to decide whether or not to impose the death sentence. So death sentences ended. About 4 years later, of course, within 4 years, states responded. They created schemes that we see today, which kind of guide jury's discretion about when to impose a death sentence. And by 1976, another case made it to the Supreme Court, Gregg versus Georgia, which reinstated the death penalty and basically gave its blessing to the schemes we see in place today. Right? So at the time, 600 people had to be resentenced from death to life without parole or life. So you had a massive shift, a really significant shift in this country. And so I guess with that kind of history, did I miss anything there? Oh, I did miss a couple things.
One small detail.
Couple small details. Go ahead.
So Peggy Cooper Davis, who many of you know is a professor here at NYU, was a very young attorney working at LDF at the time, and she worked on the Furman case and was critical to its success. And Anthony Amsterdam, who maybe is seen a little less frequently in the hallways of NYU, but he was really one of the primary architects of LDF's campaign to end the death penalty, and has been intimately involved ever since. I was here mooting with him a few years ago for another Supreme Court case, so he's still active. His finger is still on the pulse of what's happening.
Yeah. So the question I guess I want to ask you in the wake of Furman and Gregg is, do you think the death penalty is any less arbitrarily imposed today than it was in 1972? I'll start with Aaron.
Okay. Well, I guess my top line answer to that would be no, that I don't think it's any less arbitrarily imposed. I do think things, have changed, but it's just sort of the arbitrariness, I guess, has shifted, at least in my view. The reason our office is in Philadelphia and the reason it became so big was because there were a lot of death sentences coming out of Philadelphia in the 80s and 90s, for instance. And during that time, you would have prosecutions for really, it's sort of weird to say this in the context of a homicide, but when you're only dealing with murder cases and you're sort of looking at them kind of compared to one another, crimes that sort of probably fell on the less aggravated end of the spectrum, and they were getting prosecuted capitally, just pretty routinely. And a lot of folks who were convicted of things that would never ever be capitally charged today, like a single, convenience store robbery, where a killing happened in the course of that. We're not really seeing those types of cases as much being capitally prosecuted now, and a lot of the cases that we're seeing tend to be, these kind of like mass shooting cases or other, much more aggravated or serious cases that are in the news, et cetera. But I don't necessarily know that it has made it less arbitrary. The number of death sentences is way down. So it's a tiny, there's something like 15 to 17,000 homicides every year in the United States. And you're talking about a tiny, tiny handful of folks who ever end up on death row. So, the kind of, don't know, famous line from one of the Furman opinions was that the death penalty is arbitrary in the way that getting struck by lightning is cruel and unusual in the way that getting struck by lightning is cruel and unusual. And that's really no less true, and in fact, it's probably even more true now than it was back then because so many fewer people are being sentenced to death.
Yeah, and the arbitrariness is really tied to, in some ways, there is a predictability about who's getting the death sentence. And when we think about just the scale of the death penalty since Furman, so when Furman was decided, there were around 600 odd people on death row, and death row was then cleared. Today, just the state of California has over 600 people on death row. There are over 2,300 people serving death sentences still today. So even though local prosecutor offices, the federal government is not seeking death in as high numbers as the 80s and 90s was really a spike. We still have this massive population of people on death row with active litigation in appeals. The federal government, at the time that Furman was decided, I don't think there was a single person on death row. Now there are 44. Those of us remember in the last months of Trump's presidency, the rapid execution of 13 individuals. So what has changed is the scale, and that's really sort of mimic the wave of mass incarceration that happened outside of the death penalty context. So in the 80s and particularly the 90s, this massive spike in lengthier sentences, very harsh sort of prosecutions and sentences. But in terms of the arbitrariness, what is predictable about who gets the death penalty still today is that it's driven by the race of the victim. So it's mostly in white victim cases, most pronounced when there's a black defendant or non-white defendant who's the alleged perpetrator. And this is true at every stage. So at the initial investigation with law enforcement, the clearance rate of white murder victim cases is higher. Prosecutors' discretion, whether or not to charge, they have enormous discretion. The decision to charge is driven again by the victim's race. A jury's decision to convict, to render a death sentence, this is all backed up by cases and also by social science. And then it's even relevant in the appeals process. So there's been some research that people with white victim cases tend to end up getting executed actually and not as successful in the appeals process. A lot of factors obviously at play there, but it's arbitrary, but yet there is still some predictability to what cases end up moving forward.
So I guess I want to ask you a little bit about kind of how you think defense practice has changed over the course of time since, I guess, Furman and Gregg were decided, and maybe in the last like 10 to 15 years in capital cases. So I'm wondering if you can speak a little bit to that.
Dramatically so.
No, please.
Yeah, so the cases that I had one that was tried in 1981, the year before I was born. I had cases that were tried in 88, some in the early 90s. My most recent case was prosecuted in 2008. But the ones, particularly in Tennessee State Court in the 80s, the jury selection would have happened in a couple hours. There wasn't a lot of serine voir dire. The jury impaneled the state's case, lasted that afternoon. Sometimes they got through the entire trial in one day, including jury selection. The transcript for me to review was quite thin. It was just shocking because you would see a longer transcript and more engagement on voir dire and jury selection on a simple assault case that went to trial. And here this was a capital conviction. I had cases where the second chair, there's a requirement that two lawyers represented someone facing the death penalty, met the client for the first time on the first day of trial. And this was the person that was in charge of mitigation, putting on the case for life. And they're meeting the client that day. So things have changed. When I think about the recent Parkland trial in Florida and the jury's decision to return a non-unanimous vote for death. And so ultimately the young man there was sentenced to life because the jury couldn't agree, all 12. And that was because of all the energy and effort and focus on jury selection and getting jurors to discuss in what situation in a highly aggravated murder would you not return a death sentence. It's called the Colorado method. And so all the time and energy and focus on building the mitigation case, priming the jurors for the information that we're going to hear during sentencing, ensuring that they had the bandwidth and the capacity to spare somebody's life, even in the face of an atrocious, obviously multiple victim case, a lot of publicity. That level of representation is not what I saw in the early 80s.
Yeah, I would agree with that completely. I mean, I actually have multiple cases in Philadelphia where my client's attorney met him either the day of or day before trial started. And typically back then, at least in Philadelphia, you would have one attorney. That attorney may or may not have hired an investigator, and almost certainly didn't hire any experts. So you didn't even have a second chair attorney in a lot of these cases. And the prosecutor would turn over, like 50 or 100 pages of discovery. The attorney did, essentially no investigation, read the discovery mostly, probably, and showed up and tried the case without having met the client or investigated anything. So, a lot of that was kind of structural in the system in Philadelphia. I mean, lawyers were paid a flat rate, an extremely low rate, even by national standards. Philadelphia still is not anywhere close to a lot of other areas, even active death penalty jurisdictions. And so, the cases were just, nobody was paying attention really. Sometimes a day, you'd end up with a death sentence. Now, I think, and at the time, prosecutors and judges who were, intent on having convictions rendered and then upheld, were happy to kind of see these cases move through pretty quickly. Now, I think there's a recognition that there's going to be active litigation throughout the entire life cycle of a case. So you even see, prosecutors and judges kind of trying to insulate cases and ensure that the defense lawyers are doing a good job, even if their, motivation for doing so isn't because, they're overly concerned about the level of representation the client is receiving, but just because they want to ensure that they're insulating the case from further challenges. So, I think you see a pretty, not that everything is happening perfect nowadays, I mean, far from it perfectly, but you don't see quite that level of just abject breakdown that you used to.
Yeah, I mean, it was always staggering to me, like handling cases at LDF, capital post-conviction cases. I mean, I had a case in Arkansas, in Pine Bluff, where his counsel, again, met him like the day before, a couple days before trial, had like 4 or 5 other capital cases backed up. This was his first capital case. After he was supposed to represent our client, had his secretary do the witness interviews and interviews for mitigation. Somebody who's not trained to do any of this work, of course. Let alone kind of anything else. And then also had a whole other civil practice that he was fully engaged in at the same time. And just like the notion that you would do so little to represent someone whose literal life is in your hands is just staggering to me, and remains so. With that said, I'm kind of wondering how you think the Supreme Court's approach to capital cases has changed or shifted over the years, and particularly in the last 5 or 6 years. Probably in bad ways, but let's start with that. I don't know.
Sure. Well, I mean, I think that it's no secret that the current Supreme Court is, I think, much less amenable to challenges to capital sentences than it has been in the past. I think that the execution spree at the end of the Trump administration was really sort of eye-opening to me in that regard because. A lot of the rhetoric in capital cases, especially habeas cases in the Supreme Court, is about kind of deference to state, comity and federalism, deference to state courts that are, sort of co-equal courts and justice systems and things of that nature. But in the federal cases, there was none of that really, and in fact, it was sometimes the opposite. You can get the federal death penalty anywhere, including in states that don't have it as a matter of state law, and we see that, for instance, in Boston with the Boston Marathon bombing case. Massachusetts doesn't and hasn't for, I don't know since when, but a long, long time, have the death penalty, and yet the Supreme Court was still kind of like really pushing these cases through, even in circumstances where there were really significant issues. And the Boston case, for instance, the death sentence was overturned by the First Circuit and then reinstated by the Supreme Court. So the kind of enthusiasm for viewing capital cases very, very closely, it seems to be very much a trend lately. Yeah.
Yeah, and every capital case goes before the U.S. Supreme Court. We don't hear about it because they typically don't render decisions. But at the state level, right before an execution, there's always essentially last-minute challenges made before the U.S. Supreme Court. And Justice Jackson in November issued a 4-page written dissent after Missouri executed an individual, just to make clear how not okay it was from her view and Justice Sotomayor's view that these executions were still moving forward. So we see a minority of justices on the court that are speaking out against some of these executions at the state level. But we certainly don't have a majority. No one in the death penalty community is thinking about taking a Furman-like case before this U.S. Supreme Court. The sort of cases that we see that the court is granting cert on are sort of these, in some ways, exceptional sort of facts, or they're characterized as exceptional facts that the U.S. Supreme Court then must correct, but the holding is going to be as narrow, as possible. So Buck versus Davis is a case, it was an LDF case that was decided just a few years ago, but this idea that defense counsel had put on an expert who gave testimony about the fact that the client had a propensity for being dangerous, would be dangerous in the future because he was Black. And in Texas, you have to determine whether or not someone would pose a danger in the future before the jury determines a death sentence. And so here the defense counsel is putting on this information, the defense's own expert, but multiple federal courts had already denied this claim, and then it came before the U.S. Supreme Court. So there, Chief Justice Roberts, writing for the majority, says, we sentence people to death for what they do, not who they are. It's a very unique, narrow set of circumstances, and so it wasn't like a broad sweeping sort of position on the death penalty. And it's in some ways terrifying to think about taking a global challenge to the death penalty before this court. But I think we'll continue to see these sort of narrow questions brought before the court in the hopes that you can get these sort of somewhat exceptional cases for the court to rule in your client's favor.
I just want to make sure you all heard that correctly. The client's own attorney put on an expert witness, who said you're more likely to be dangerous because you're Black. And that was a real question about whether or not you're going to grant relief. I remember litigating that case. He'd been denied. He'd been denied repeatedly. We litigated that case at LDF when I was there. We had to go through several rounds, the Fifth Circuit, Supreme Court. We only got relief because another Supreme Court case was decided that allowed for the type of appeal that we were seeking. And that was a real question, right? Which kind of gives you a sense of the state of affairs.
At the court now.
At the court more generally, right? And that was before the latest kind of set of folks that we have now. I guess speaking kind of to the core, I'm wondering if you can help us understand what some of the court's more recent habeas jurisprudence this past term means for capital litigants. And I guess I'd have to ask you to talk about what habeas actually means too. I think we kind of dove into that without defining our terms. So,
sure, yeah. So, habeas is, I also didn't take federal courts in law school, so I was, learning about this early on in my career, in my current
Now
job.
you could teach it.
But yeah, I mean, federal, 98+% of death sentences nationally are state court convictions, not federal convictions. So, but you are able to challenge federal convictions, not just in capital cases, in any criminal case, in federal court as sort of the kind of last set of challenges that you can raise to any criminal conviction. So you're basically petitioning a federal court to say, my underlying criminal conviction or sentence is unconstitutional because the trial was unconstitutional for one reason or another. So you're raising constitutional challenges to the underlying criminal conviction, and basically the federal court has the ability to say, yes, this conviction was unconstitutional, so you, state state X either have to retry this person within a certain amount of time or release them because they're not incarcerated pursuant to a valid conviction or sentence at that point. So the whole framework of habeas law and what it looks like has changed kind of at some points gradually, at some points dramatically over the years. The current habeas statute that we're dealing with every day was passed in the mid-1990s. It's called the Anti-Terrorism and Effective Death Penalty Act. But there's often been strains of kind of hostility towards habeas and sort of the whole idea of federal courts being able to set aside state criminal convictions in general by some judges. And this court, or at least the majority of this court, definitely has seemed to take up that mantle in recent opinions. Two in particular are Shin versus Ramirez, which sort of undid the procedural mechanism that Mr. Buck used to win his case that had only been put in place by the Supreme Court just 10 years earlier or something like that. And so they're really kind of paring back the ability to get habeas relief in cases.
Yeah, and I think the scary thing about a couple of these cases from this last term is essentially what they're saying is you can satisfy all the elements of the statute, the habeas statute, and we still don't really have to grant you relief. It's only if justice requires it, right? And so you're not kind of guaranteed to obtain relief just because you met the elements of the statute for relief. Basically, it's still within our discretion, and we still kind of could grant it if we want to or not. And that's a really, really scary place to be.
Well, and the frustrating part about it is the underlying claims are meritorious. And because of procedural barriers, you can't bring them before a federal court to get a decision on the merits. And so this window of opportunity for relief is quite narrow. And I think about LDF's death penalty docket in the sort of after Furman, after the death penalty was reinstated. And LDF was able to get relief in a lot of cases in the late 70s, into the 80s, 90s, early 2000s. And then once EDPA was decided, which now President Biden was a senator, was part of that sort of wave when Clinton was president. But EDPA has really slowed and closed the opportunity for relief.
1996 was a very bad year. It was immigration reform, welfare reform, and death penalty reform, right? In all terrible ways. I guess if we're thinking about moving away from the Supreme Court, I'm wondering why we're seeing what the state constitutional challenges look like, and maybe are we seeing more of those come up? Alexis, maybe you could talk about that a little bit.
Yeah, there's a lot of exciting movement in state courts and in individual states. To give you a quick snapshot, about half of the states still have the death penalty. I did mention California is the largest death row, as a governor instituted moratorium. Several counties in that state no longer seek the death penalty, LA County, some of the northern counties, and they were the driving force behind the death penalty in that state. And what I find most interesting, and this is actually a pretrial challenge in Kansas. So this is a young man who's alleged to be involved in a double murder in 2020, very recently. His case is slated, Kyle Young, before sort of trial court in Sedgwick County, it's Wichita. And his lawyers, with help from Hogan Lovells, large law firm, the ACLU of Kansas, filed a massive motion challenging the constitutionality of the death penalty under Kansas's constitution, which has greater protections than the federal constitution for the right to life and to liberty and to happiness. It's embedded in their constitution. Their argument is that it's arbitrary, that it's racist, and they put a lot of sort of pretrial affidavits from experts, and they're having a hearing next week. Jeff Fagan at Columbia Law, who's a leading researcher in the race of victim being the driving force in a capital case is testifying. Liz Simmel, leading national expert on racial discrimination and jury selection, is testifying. Mona Lynch, leading expert in jury issues and how jurors weigh mitigation, is testifying. And this is part of a multi-year campaign to challenge Kansas's death penalty under Kansas's constitution. And I am cautiously optimistic that has the potential to be successful. Kansas has a death row population of 9 individuals, but to be able to knock out the death penalty from another state is something that the US Supreme Court takes stock of. How many states? What's the national trend? And so I think it's very exciting. And if you're thinking about, is this work I should get involved in, doing this at the state level, there's a lot of innovation that's still available.
Now, I don't mean to temper any enthusiasm, but I want to ask about what you see as the role of the executive branch in Congress in dealing with the death penalty. I don't know, I'll start with you.
Sure. Well, you know, I don't think that there's anything, at least that I'm aware of, stopping, for instance, President Biden or any president from just broadly commuting all death sentences. You know, I think that there was some hope. I don't know how naive that hope was that such a thing might happen at the end of the Obama administration, but obviously it didn't in a broad scale way. And so, of course, then we saw what happened during the Trump administration. You know, certainly that type of action could be taken. It was taken by the governor in Illinois a number of years ago. I forget the exact year. Basically, on his way out of office, Illinois had a huge death row population, and then, you know, essentially one stroke of the pen was, you know, that was the end of the death penalty in Illinois functionally, because, you know, nobody wanted to sort of bother restarting everything back up at that point. So, you know, it varies state by state. Some governors have that ability, others do not. But you know, it depends on there being the political will, obviously, for whatever you know, executive branch officer, whether in the United States or in the various states, to actually take an action like that. And, you know, for all of the trend lines that are, you know, heading in the direction of fewer death sentences, even in the places that have historically been most enthusiastic about the death penalty, it still, you know, takes some political capital to do something like that, I imagine. I mean, I'm not a politician, but, you know, I think that's probably the reason why we're not seeing it, you know, more broadly, even for you know, governors or executive branch officials who might, you know, agree in principle with some of the problems with the death penalty.
And it's interesting because Biden did run on a platform that he was against the federal death penalty. Merrick Garland, obviously the Attorney General, what's significant about his relationship to the death penalty is that he prosecuted Timothy McVeigh, the Oklahoma City bombing. And now in his role as Attorney General, what he has done is issued a recent updated memo, I think just on the 30th, two days ago, giving protocol and guidance to U.S. attorneys on what to do about sort of pending cases that may be death eligible. So the federal government recently withdrew death sort of requests from 25 cases. So there were 25 cases at the federal level that were going to move forward with death prosecutions, and so they withdrew. The case they didn't withdraw from is about to go to trial just down the street in federal district court in the Southern District of New York. Mr. Sapov's case was not withdrawn. And that's an individual who drove a truck up the sort of west side in 2017 in October. So despite Biden's position, despite the federal government withdrawing death notices, there are some cases still moving forward. And there are 44 people on federal death row. Biden could, with the stroke of a pen, get rid of their death sentences, but the government is still actively defending those death sentences, filing briefs, refuting our briefs that the death sentence is unwarranted. So it's frustrating because Biden has a public position, but yet the DOJ is still sticking their heels in on some of these cases.
Yeah, so I wanted to ask you about Mr. Sapov's case. How many folks, just by show of hands, knew that there was a capital trial happening right now in New York City? Okay, so not a whole bunch. So he was convicted, and the penalty phase is going to start in about 2 weeks. assuming that a motion that the federal defenders just filed seeking to strike the death penalty because of its arbitrariness, Q Furman, is denied, right? And so I think the thing that stands out about Mr. Saipov's case, as you said, is that this administration has not sought the death penalty in a whole host of cases. And in that motion, the federal defenders filed, they talk about how they've elected not to seek the death penalty in like 400 cases, right? And so why do you think it is that out of all these cases, there was a horrible tragedy in El Paso, 23 people were killed, no death penalty sought there. There were other cases here in New York. There was a police officer turned drug dealer who murdered a bunch of folks, didn't decide to seek the death penalty in that case. Why do you think it is that Mr. Saipov's case is such an outlier? Because it does seem completely arbitrary in the same way that getting struck by lightning is cruel and unusual and arbitrary.
I mean, it's characterized as a terrorist case. Mr. Saipov was originally from Uzbek. I was living in New Jersey, but that's directly tied to why Merrick Garland has decided to hold on to this case in particular, and has made comments that they intend to move forward on sort of what they define as terrorism cases. But sort of what about domestic terrorism that clearly happens here too? And so why that line? But it's all tied to politics. Obviously, the government has discretion to exercise, and they're exercising it in a certain way in cases that they characterize as sort of international terrorism.
Yeah, I mean, I don't know that I have a good answer to that. It's a bit of a mystery to me. And even in other big prominent kind of mass casualty type of cases, why one decision gets made versus another. And without being kind of privy to the inner workings of any individual case, it's a little bit hard to say. I mean, there could be, for instance, a local U.S. attorney or somebody who's in the local U.S. attorney's office who's just really, for whatever reason, is like very strongly advocating and pushing really, really hard. And at least as I understand the DOJ's process for how they authorize and decide to move forward with capital cases, the recommendation from the local folks who are actually prosecuting the case is going to be given a lot of weight, even if it's not fully determinative. So it could be something as simple as that. It could be, it's really, there's no telling, at least from the outsider's perspective, to know how or why these decisions are getting made in one case and seemingly a non-consistent manner in another case.
And Mr. Saipov is willing to plead guilty for a life sentence. And so I think this does have something to do with the local jurisdiction wanting to put on that kind of case. This was in play in the capital federal case that I had. There had never been a federal death penalty trial in the Eastern District of Tennessee. And the judge made these comments on the record. The local U.S. attorneys seemed to be looking forward to having this professional experience. And that was definitely part of the decision.
So a couple last questions before I open it up to the audience for questions. What do you think has driven the success we've seen to date in terms of at least driving down the number of capital prosecutions and death sentences being carried out? And what do you think it will need in order to ultimately lead to the abolition of the death penalty?
Sure. Well, I do think that, I think that, one, the sort of media landscape is very different now from the way that it was previously. A death penalty case in, whatever place, may not have made much news beyond that local newspaper. Now these things are being, tracked by, different death penalty organizations, on the state level or more nationally. Resources are being, paid attention. There are nonprofit groups, for instance. There's one in Pennsylvania that, goes around statewide even for cases that are just being handled by local attorneys that don't, have a great deal of resources. They provide, resources to kind of back them up and training and things like that. So the level of practice, although, it's not at the level where it should be, has improved to the point, I think, that it's making it, prosecutors are thinking twice about the level of effort that they want to put in before deciding to move forward with a capital prosecution. They realize it's not just going to end with the end of the trial, but it's going to be a whole long process over 20 years, whatever. So even in the places like Texas or Georgia or Virginia was historically one of the biggest executing states where there has been this continued enthusiasm for the death penalty over many, many years or decades. We're seeing it precipitously drop. I think, again, it's hard for me to say exactly, but I do think a big piece of it is that it's just becoming that much more challenging for prosecutors. They're having to do so much more work. It can't be the type of thing where they can just kind of ram it through with a defense lawyer who's going to meet their client the day before, and then that'll be that. I do think they're sort of thinking twice, and jurors. Are responding to the higher level of practice and imposing death sentences less frequently, I think, as a result.
Well, and I think, too, the public appetite for the death penalty has waned. It's at an all-time low. It hovers at about the low 40% of people that are against the death penalty. I think about growing up in the context of Cops and Law and Order, the early versions, and how inundated we were. With the idea of the state and the prosecution, and there were two sides to every case: the prosecution and law enforcement and the police. And it's like, that's the same side. But that's how we were conditioned, right? And then I think about Serial, the podcast, when that came out, an Adnan's case, and everyone was transfixed with the idea that there could be a wrongful conviction. And I think about all of these more nuanced sort of shows that are showing, even if someone has engaged in an unlawful act, in an aggravated murder, there can be things wrong with the process. I think we have a much more nuanced understanding as a society of how it is that people engage in criminal conduct. They're not bad people. Bad things have happened to them. Hurt people hurt people. We are understanding this so much more as a society, and it's important because society that's who ends up on juries, and so they're less willing to render a death sentence, combined with all of the trends that Aaron is identifying, and so it's a combination. We no longer call children super predators the way that they did in the 90s. As frequently. But I do think there is this sort of systemic shift as a society with our understanding of crime.
And I guess last question before I kind of open it up to folks is what advice you might have for folks who want to get involved in this fight, and particularly the folks in this room and who are watching. We're thinking about law students and about anybody who's really kind of engaged. I don't know, we'll start with you and then give Alexis the last word.
Sure. Well, first of all, I would highly encourage it. I think it's a really, fulfilling and important line of work. I would, suggest to folks that particularly if you're interested in criminal defense as a career, kind of more broadly, one sort of plug that I often like to make when talking to students is, if you are interested in trial work, or you think you might be interested in trial work, I would suggest kind of going that route first. I think it can be harder to sort of get, head in that direction later on, not necessarily because of, obstacles to getting hired or anything like that, but because, trial work has its own sort of pace, and you have to be in court every single day. And, once you get a little bit older, and if you have families or whatever else, the habeas work that I do is very busy, but there's also some, flexibility. I can be working late at night. Whereas, if you have to be in court every single day because you have to be in court during business hours, there's not that flexibility, or there's less flexibility anyway. So I think if you are interested in that, it's great to do right at the beginning, develop your courtroom skills, even if you're later using them, in non-jury trial settings. And then, even if you're heading to a firm and not, looking to get involved in criminal defense directly right out of law school, we often are partnering with firms on sort of ancillary litigation relating to lethal injection challenges or other things. Firms often sometimes do pro bono cases where they're handling them. So certainly if you're going to be working at a firm or something like that, and you have the opportunity, obviously I would suggest volunteering or anything that you could do to get involved. if that's your career path. But
Yeah, it's incredibly dynamic, innovative work. It requires imagination. It requires dedication and persistence. And I highly encourage it, whether you're doing trial work, post-conviction, or on the policy side. So there are a number of organizations. The Death Penalty Information Center has been critical about sort of changing the tide on the death penalty by just collecting information about what's going on in every state, what's going on at the federal level. And we need smart people in those organizations as well as doing direct representation. If you're curious about sort of the landscape of organizations, Berkeley Law School, their death penalty clinic, has a list organized by state of every single sort of death penalty organization, mostly doing direct representation, whether it's the Capital Habeas Unit of a federal defender office or MacArthur Justice Center that has sort of a death penalty docket. They've got it all listed. So Google just death penalty Berkeley Law Clinic, and you can find that list. And so it's a great place to get a sense of the organizations, but also places you can intern at over the summer, potentially do an externship. There are places in New York City where people are doing direct client-facing death penalty representation and advocacy. And so I highly recommend it. And if you have questions, I know we have just a little bit of time, but I'm an available resource to you. You can find me on Brooklyn Law's faculty page.
I'm going to put a plug in for PILC at the law school.
This
Sorry,
week,
Lisa.
right?
Yeah. Yeah, this week. There's a career fair? Yeah. So there will be also opportunities you can explore there as well. Mm-hmm. I just want to invite folks up. There's microphones here at the front of the room. If folks do have questions that they want to ask, now's your chance. I could probably ask a couple more questions myself, but
I see questions in the eyes, but I think the
yeah,
microphones,
yeah,
can be intimidating.
You can raise
So
your
come on
hand,
up.
just talk if you want to. Oh, there you go. All right,
Yeah.
nice.
Hi.
Hi.
Thank you. So you spoke about advice you would give, but if you could go back and talk to yourself while you're working on your first capital case, what is something that you've learned over the course of your career that you would give to yourself in the past?
Good question.
Yeah, that's a really good question. I think I was very naive personally when I was just getting started out. Everything was very new to me, and it was personally I was working on cases in rural Georgia, so I was driving all throughout the state of Georgia handling cases. So I was taking in so much information, just kind of being in a new place culturally, everything that it was a complete whirlwind for me, and it has been, over the last several years that I've really started to come to grips with how little I actually knew back then. So just, I think the importance of staying humble, especially as you're starting out, really throughout your career, in all ways, is really critical because, you are, obviously doing important work on working on your client's case, but your client is living it. He's or she is, they are, going to be the ones dealing with all the impact. So I do think it's important to kind of approach the work with that mindset.
Mm-hmm. Mm-hmm. The first client I ever had was someone who had been sentenced to death. And so I was very much learning as I was going along. And I think some of the most helpful lessons that I received, which I would repeat to myself now, were spending time with investigators, the mitigation investigators who were exceptional listeners. And we don't do as good of a job at that as lawyers. We like to talk. But if I could remind myself to listen to my clients, to my colleagues, to witnesses that I was with, to be comfortable with silence, I learned so much in those moments.
Other folks, yeah.
Hey.
Hey.
So this is a little in the weeds, but I'm curious whether you could speak to any worries you have about the future of the evolving standards of decency standard. That's like the guiding Eighth Amendment standard, right? But then in a recent Supreme Court case, Bucklew, the Supreme Court didn't cite that standard at all they've done this thing where they love to do this like two-step where they don't cite something, and then in a future case they say, well, we've abandoned that. Look at these cases where we didn't cite it. And so I'm just curious whether that's something you're worried about, and what, if anything, how folks are thinking about that.
I mean, yeah, I very much am worried about that. I mean, I feel like I don't have a great sense about where the court may head next, or what some of the recent decisions. I would not necessarily have predicted that sort of this type of language that we see start to now bubble up would have been included in Supreme Court opinions. So, I mean, I don't personally know what a great strategy is to sort of insulate against that proactively. I mean, you've got your client, you've got to represent your client, and if you need to appeal that case to the Supreme Court because that's the next avenue you have, nothing's stopping them really from issuing an unhelpful decision in any particular case. And so many of the issues that we're dealing with, like the evolving standards of decency, jurisprudence is just so central to basically any capital case, and so many of the claims that you're raising. So it's hard to see how you would, successfully kind of insulate against future negative cases in that way. But maybe you guys have better ideas about it.
I don't have any better ideas. I mean, this court is terrible, and I don't have like I'm not. I mean, I don't think that takes a legal genius to see that. We have a really tough road ahead of us, and I think part of what I guess what keeps me hopeful is the work that's happening in state courts that Alexis alluded to earlier and described earlier. And I think, if you think about this in terms of the long game, and we know that Furman kind of started off as being sparked by a dissent, and thinking about who is dissenting now on this court, and how those dissents hopefully will one day become the law of the land and majorities. But I think that's part of the fight that we're all in, is that this is a long game, and that it is, hard work and long hours, and there's kind of no denying that. I don't know, Alexis, do you have any? I don't know if you have any. Nothing. All right, all good. We have one more question. Yeah, sure.
Yeah, I was struck by the story you told about the man being told he's dangerous because he's Black, and how predictions of future dangerousness are still so prevalent in the law, even though they're based on basically nothing. And that's maybe one element of our culture that even as much a lot has changed in terms of the kinds of movies we see, true crime is still so popular, and we still think about danger in this. Yeah, and I'm just curious if you could speak to that on how you see the culture moving in that and changing the way we think about dangerousness in the law.
Yeah, it's really problematic that's part of the calculation. That's embedded in Texas's death sentencing statute. So it's a question that every advocate has to address. And there was a really awful attempt in Mr. Buck's case to preempt that argument from the state by providing their own racist support. It's an issue that is currently before the Supreme Court in a slightly different sort of procedural posture. In the state of Arizona, there are individuals sort of caught in this window of cases that came down from the US Supreme Court. But they wanted to be able to say that if, jury, you don't return a death sentence, I will be sentenced to life, and there's no way that I could be released on parole. And judges weren't allowing them to share that information. It had to do with this idea that, would they pose a danger, essentially, if they were going to be in general population, and the judges weren't allowing them to put forth that information, that they wouldn't have, they won't be released from prison if you don't sentence them to death. And so it's a challenge right now, and the challenge actually has to do with Arizona's state post-conviction procedural rules, called Cruz versus Arizona is the case. and it was argued in November. And there was a lot of back and forth from the judges about, hands off. We're going to, we respect federalism and comedy. Many of the issues that Aaron was speaking about earlier, to sort of avoid the merits of this issue on dangerousness. And yeah, it's deeply problematic. And this plays out in other areas of the criminal legal system with risk assessments. And these automated risk assessments, which I know Vincent can speak about at length. But it's this idea of predicting somebody's chances of committing crime. How can any of us do that?
Yeah, and I mean, we sometimes work with, experts who are former prison officials and stuff like that, who are, charged with making those types of determinations. Prisons, probably every prison system in the country has some sort of initial kind of intake classification procedure where they're sort of charged with doing, in part, that, and they place, different folks at different custody levels and things like that. But whenever I'm working with somebody like that, and whenever they're testifying, they talk about just how counterintuitive a lot of the stuff that they actually think about in doing that work on a day-to-day basis is for a capital jury, for instance. And the prosecutor kind of will usually get up and say, well, of course this person's dangerous. Look at what they were just convicted of. But what these prison experts talk about is that that it has like such a low level of correlation with whether or not somebody is going to specifically be committing acts of violence in the very structured prison setting, which is not in any way like the setting where they were convicted of committing the crime that they did.
So I got the signal that we're out of time, but thank you to our phenomenal guests for such a wonderful conversation.
It was really great to meet you and hear about your work.
What's that?
It was great to meet you and hear about your
Likewise.
work.
Yeah.
Thanks all of you for your interest in this topic, and really encourage you to go out and do this work because it's so incredibly necessary.